Hello and welcome back, everyone, to Immigration Talk Show. I'm your host, Sam, and today we are here. Very exciting episode that is lined up just for you today. So make sure to watch this session till the end. And also, it would be lovely, friends, if you could also participate here by commenting and by asking as many questions as possible. But before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information shared by our experts and attorneys, including user comments and replies from users, is not a legal advice. So, use of information is at your own risk. All right, friends, after this very important disclaimer, also let me tell you that we are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. So check out us there and also like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. And with that, friends, we have another very important topic, and this is the second segment of the topic that we are going to cover in today's episode. That is about H-2 visa, how to legally sponsor workers in the US and work as a seasonal temporary worker. So, the first episode was really a great one, a wonderful one. We got a lot of questions over there, and some questions were even left, and it wasn't possible for us to cover all those questions in an hour. That is why we are here with another episode, and to make this episode even a great one, a wonderful one, we have really a very special guest with us who is joining us for the second time in Immigration Talk Show. And personally, I'm also very excited to have a show with her because our first show was really a great one. So thank you so much to our attorney who is going to join us, none other than attorney Meagan Kirchner, who is the founder of Kirchner Law, a PLLC with nearly a decade of experience in immigration law. So, Megan is an expert in H2A and H2B matters. Thank you so much, Megan, for being here. And we are really honored to have a show with you. So, thank you so much for joining us right now.
Hi, Sam. It's great to be here again.
Same here. So, Megan, before diving into our questions, I would like to know what our audience can expect from today's episode.
We'll get into a little bit to touch about, of course, the administrative change and, what we have seen coming, rapid fire just in the past month, as well as pick back up on some H-2 questions to um, cover more of what employers and prospective H-2 visa holders can expect from the program.
All right. So I think we got the gist what we can get to know from our today's episode, friends. It would be lovely to ask questions and participate in this webinar because we are here live for an hour, and we'll try our best to provide the best solution and, of course, the expert advice to your questions. And with that, let me start with my very first question. That is, Megan, could you let us know that how might the shift in the U.S. administration is going to impact immigration policies, particularly in areas like employment based visas and family reunification programs?
So changes have already been underway, as I mentioned, since the day the administration changed. It's been a flurry of executive orders and rescissions of prior administration policies. It's impacting tremendously at this point more on the family side. As many are aware, the new administration has reinstated the Remain in Mexico policy, which really is a tremendous hardship on those trying to seek asylum. They're really stuck in limbo, south of the border until such time that they're allowed to submit their applications. Another impactful family-based program that a lot of people have come to rely on is TPS, temporary protected status, and that's ending for Venezuelans. It's two-tier. It has ended for some already, but for many others, it will end this fall. The same thing with Haitians. So, this has tremendous impacts for individuals in the U.S. who have been have gone through the proper channels and have work authorization and, the ability to be here and work and be productive. And that rescission will cancel their work permits and put them at risk of rapid deportation. The developments thus far have not been positive ones. Related to asylum, CBP also announced that they canceled their CBP-1 mobile application, which allowed asylum seekers to schedule their appointments. And when they canceled that scheduling functionality in that app, many appointments were canceled without the ability to appeal or question or reschedule. Um, so those are just a few of the family-based issues that have already come
Hmm.
from the new administration. As far as the employment-based visas, there hasn't been any formal, really, um, action to cancel any programs, but there have been actions taken that make them, more challenging. We've seen increased enforcement from ICE and USCIS's fraud unit in employment-based visas. So employers have had site visits, I-9 visits. Everybody is spreading information about the Know Your Rights campaign so that businesses know, what proper documentation officers need to what they can ask for, what areas they're allowed to be admitted to, what information or areas they should have, warrant for or court order. And so, this has been something that's impacting people that already have been through the process. These are companies that are, already have people that have visas or work permits. So those are ongoing, and you see it all over the news. It's increasing in frequency. Another specific to H-2B, an impactful action isn't directly immigration related, but the supplemental visas that we talked about last time have been impacted as far as scheduling. There were several offices in those Northern Triangle countries, Honduras, El Salvador, and Guatemala, that had ministry offices that received USAID funding. And with USAID funding being cut, those
Hmm.
offices have either shuttered or are severely backlogged because they're understaffed or under-resourced. So employers in H-2B looking to use those resources to schedule their worker appointments or recruit new workers haven't been able to do that. So they're left with the only option they can use for those countries is private agents. So private companies that can schedule worker appointments or act as a recruiter, which costs those type of private party recruiters cost money versus the government offices that did it without cost. Other than the normal visa fees and consular fees you would pay, there was not a separate recruitment or scheduling cost. So those are direct results or
Hmm.
complications from the administration change. And just last week, they also noted, Department of State noted changes to consulate Dropbox eligibility. So, for instance, someone who was on an H-1B or an L-1 and wanted to switch to O-1 or another visa class, previously that Dropbox allowed them to, drop off their passport, get the new visa without having to schedule a consular appointment to go in person for an interview. They've restricted those eligibility requirements to do a Dropbox appointment. There's a shorter renewal window. The expired passport that you're looking to renew, or excuse me, a visa, has to have been expired in the past 12 months instead of 48 that it was before. So there's a lot less flexibility there. The renewal has to be in the same category. So you can't switch categories, like I said a moment ago. You also can't have had any prior refusals. You have to apply in your country of nationality. And there's also, what this is going to mean is the return of months-long wait times for appointments abroad. So this was particularly impactful in places like India last time during COVID, or during when the interview requirements were enforced. So these are changes that have come quickly, and none of them are particularly positive as far as making any immigration any easier or more friendly to any of foreign nationals or companies.
All right. Well, I think it's really a tough time for everyone, because we have been going through a lot of executive orders, and it's really tough for everyone, not only for US people, but those who are looking towards
Oh
in the
yes,
process of immigration. All right. And there are more questions, Megan, I would like to
sure.
know. obviously, you said that what are the changes that we might have seen in immigration policy, especially the employment based and the family reunification. I would also
Mhm.
like to know beyond DACA, what areas of immigration policy do you anticipate becoming more stringent under the new administration?
Sure. So, what we're expecting coming down the pipeline is, foreign nationals that are applying for visas at consulates or embassies abroad are going to have more often they're going to be put in administrative processing. That's going to become more common as things get because they've already professed how they want to be more stringent and more comprehensive. So rather than officers being able to make a decision, same day based on what's presented in front of them, there's going to be more likely that your application may get put into secondary processing where they need more information or they have to take more time to review the application, which obviously is going to slow down people's ability to come work or process their applications. During visa interviews, some foreign nationals, much like under the prior iteration of this administration, um, you know, high risk countries are going to be more likely to encounter higher scrutiny, whether it's fair or not. That is likely going to happen again. Regardless of their current country or nationality, they may be asked about their ties to high risk countries just based upon what we saw last time under this administration.
Mhm.
I already have talked about the consular delays with just Visa Dropbox, but they've already cut funding and staffing across many government agencies and offices. Um, the federal workforce is being, cut back tremendously. So that may bleed over into USCIS processing, Department of Labor processing. All of those times may increase substantially. So, many of these issues are going to result in not just visa issuances being delayed, but every step in the process, from, like, for instance, if you're looking at a green card, your Department of Labor processing for both your prevailing wage and your green card or your perm application are going to be, they're already long and they're just going to get longer. We also expect the return of some form of travel ban. So
Mhm.
um, there were certain countries where they had travel bans during the last administration, and there's an expectation that those will make a return in some way or another. Um, and also because of the nature of the orders, it's more likely that requests for evidence and denials will be issued for filings with USCIS. It may not be a formal written change to policy or approval guidelines, but generally speaking, you know, rates
Mhm.
of requests for evidence or notice of intent to deny were substantially higher um, during this administration's first run, and it's fully expected that that will return now. Um, there's lots of changes that we would foresee. There's not some of these we can't prepare for,
Mhm.
but other ones, as far as the ones related to timelines, just be proactive. If you're traveling, be sure to schedule your appointments ahead of time, or don't schedule your travel until you know you're able to get an appointment so you're not stuck outside of the country unexpectedly. If you have renewals to do and you're eligible, don't delay filing those, because like I said, these processings, you never know on the family side whether your category will, no, you're no longer be eligible for some in some way, whether they change some policy or, you know rescind some application like TPS, that those, while you're able to file your cases, you should
Mhm.
do it now, because it's not going to get any easier or faster, whether you're looking at family or business.
All right. Thank you so much, Megan, for putting up these very important pointers and that too in a very detailed manner. I'm sure our audiences are really liking this and, they are filling themselves with lots of different information. With that, Megan, do you think that obviously DACA is, we are not expecting this program to be anymore. But do you think that there will be some problems regarding asylum seekers also? Will the asylum seekers won't find a US for their future? Do you think that may ban in the upcoming years?
It's too early to tell whether they're going to wholesale ban those kinds of applications. I think that that would be something they would want to do. I just don't know whether legally whether that's going to be feasible for them. Um, but everything right now is very much in flux. So I don't want to expect the worst or say something bad is going to happen that I can't have any way to predict. But everyone should exercise caution at this point, going forward.
Absolutely. Absolutely. I think that's really early to say anything, but let's hope for the best and let's look what happens. All right.
Okay.
With that, Megan, here's another question: that how must employers recruit American workers before seeking H-2B visas, and what documentation is required to prove their recruitment effort?
Sure. We touched on this a little bit last time, but as part of the H-2B requirements, employers are required to test the U.S. labor market to prove that they're not, disadvantaging any U.S. workers, and they're required to hire U.S. workers first. As part of that process, they have to post an internal posting notice once they have been issued a notice of acceptance by Department of Labor. That it goes in two places at their place of business for their U.S. workers to see, make referrals to apply to the job if they're interested. They're also required to, their job gets posted on seasonaljobs.gov. The government posts that for them, and they have to field applicants that are qualified U.S. applicants. They also post their job proactively on their state workforce agency website. And again, must field any U.S. applicant, interview them, and hire them if they can't be lawfully disqualified, or if they're not, if they're not interested. Obviously, they don't have to hire them, but they have to go through that process to ensure there aren't any U.S. workers that are willing to fill the job. Another key recruitment item is contacting prior U.S. employees. So any U.S. employee that was laid off, or pretty much any U.S. employee that has worked for them in the past year that was not terminated for cause or didn't quit or abscond, are supposed to be notified of the opportunity. And they have to keep, as part of this process, again, they have to keep evidence of this. They have to fill out their recruitment report and write down any applicants and what the outcome was. They have to keep copies of their posting notices. If there are interviews, they need to keep their interview notes. And I'd have pictures of their posting notices to make sure that they've posted them as required. They also need to have copies of their certified mail for sending the letters to prior U.S. workers. These are all very important items they need to keep in their audit file for at least 3 years, in case the government asks for evidence that they've complied with all of these requirements in order to protect U.S. workers and ensure the U.S. labor pool is such that they need the H-2B. They're testing the market to prove that they can't find a qualified U.S. worker.
All right. So, Megan, I would like to know it from you that mostly we have seen for the H-2 visa applicants, we have seen mostly the foreign workers, not the US workers. So,
Mhm.
can you put up some reasons, like what can be the reasons behind there are more foreign workers for H-2 visa applicants as compared to, than the US workers?
So for U.S. workers, some issues with the H-2 positions are that they're seasonal by nature. The nature of the program is it's a full-time job, but
Yeah.
they are temporary in nature. And a lot of U.S. workers want full-time year-round work, not work that they can only work for 9 or 10 months and then they have to find another job. So, short of college students or young people, most don't have interest in working a job that isn't going to provide them that stability.
Yeah.
Um, a lot of this work is also very labor intensive. So, we've got a gap in some of our U.S. industries for workers that, you know, don't,
Mhm.
you know, don't have a degree and don't want to, work in this the types of jobs that are available. So there's a variety of reasons that U.S. workers may not be interested, but I think the largest is probably that the way the economy is, and they really need work that's more reliable. It's very reliable and with full-time hours for a season, but the rest of the year they would be left with needing to fill that gap.
All right. I think that was a much important point to put up because most of the people they don't know what is the reason behind, and they're just
Mhm.
blindly applying for that. But thank you so much, Megan, for putting that up. And also, recently we have got to also know that in agricultural sector, we specifically talk about that. Then we have seen that there are I think 2 or more million illegal immigrants are there, and current administration is trying to deport all the illegal immigrants. And for agricultural sector, there are majorly illegal immigrants who are working and working well. So, do you
Mhm.
think, Megan, that if those illegal immigrants will be deported, then U.S. might face some food crisis in the upcoming years?
It's certainly a possibility. I don't have the statistics in front of me. I did post one on my LinkedIn a
Okay.
few months ago when right before the administration shifted, or right after they announced that they were really going to be focusing hard on undocumented workers. Construction and agricultural both heavily rely on undocumented workers, and the labor gap there's already a labor gap. There's already shortages for agriculture. There's already shortages for construction and
Mhm.
subcontractors. So those will only be further inflamed if that this workforce that they come to rely on isn't an option anymore. I've had some employers reach out that are worried about this, and there's not really a good way to fix it. They could switch to the H-2A program for agriculture. For H-2B, it's a good option for construction, but it's so overdrawn already that if they perform as many deportations as they profess to want to
Mhm.
do, the gaps that these will have in these critical industries are going to impact the economy. They're also going to require some changes to the lawful immigration side, because of the gaps in U.S. employer and employees and labor that we've already talked about. If we can't fix, if we're going to cut off some of the undocumented labor, then there's going to need to be more viable options for lawful immigration. And H-2B is already capped. The cap hasn't changed since the 90s, and many things have changed, and it's overdrawn. There's twice as many, or no, 3 times as many applications in the spring for H-2B workers than there are visas available often, and so if those number of applicants and clients or employers are looking for H-2B, they are going to be applying for a program that already has woefully too few visas available than demand can supply and demand. It's just supply is far too short for the amount of demand we already have. So as you said, if these critical areas are cut off from
Mhm.
the types of labor they're used to having, they're going to turn to H-2A and H-2B, and I don't know that there's capacity to help them.
Mhm.
There's going to need to be changes.
All right. That's right. Okay, then I think we are also getting to know a lot of different aspect of our today's topic with that. And here's another question to me, Megan, that given that the supplemental H-2B visas are announced early in the fiscal year, so how can employers best plan ahead to ensure that they can meet their seasonal and temporary workforce needs?
So the H-2B process involves 3 different agencies. We've got Department of Labor, USCIS, Department of State, at different stages in the process. Um, with the supplemental visas that they've done in prior years, again, this is a brand new administration, so we're just hoping at least for status quo. Obviously, it'd be nice if we could have some pressure release and fix the visa numbers or fix some part of the program to provide some relief on the cap or additional cap space or something to change. But at the very least, if they can continue supplemental visas as they have in recent years, that, what people can do is really, plan early, file their applications on time to have the best chance in the lottery. Once we get the lottery results, whether or not you're open, having some flexibility and being open to workers from the country specific allotment can help you, because in prior years, the country specific allotment has not been used fully.
Mhm.
This year, we expect the new administration to count visas more closely to their caps. So the initial visa cap of 33,000 for the spring is going to be met quickly and fully. And then once we move on to the supplemental visas and look at returning workers, in prior years, those have lasted through groups B, C, and D, and maybe a little bit of group E. This year, if they're counting them closely,
Mhm.
it's questionable as to whether any employers that were assigned group E are going to be able to use returning workers. So having some degree of flexibility to be open to a workforce that may be new to you. So using workers from those other countries that may never have had an H-2B visa in the past, that can give you a better chance of having workers staff this year. Another option is attempting to recruit in country. There are some agents that can help you recruit in country workers. There's also, Facebook groups, places that employers can turn to for workers that may have winter visas that are ending and they can do a transfer. That's one way. If you're
Mhm.
not open to supplemental visas or miss the supplemental cap, H-2B workers that are in the U.S. are cap exempt. So if you do a transfer from another employer, you can get workers that way. Or if a worker received a winter visa in their home country, you can do a name petition to get a worker that had a visa after October of last year. So during the current fiscal year, they can't be counted twice. So they're cap exempt by virtue of already having had a fiscal year 2025 visa. So, planning helps you with the supplements, but also being flexible can really determine whether or not you get workers at all this year. There's only so much planning you can do if you're only wanting these 5 workers from this particular country, and the cap's already been met for returning and primary cap, and
Mhm.
supplementals for country specific aren't going to help you. So,
Absolutely, that's correct. All right, and here's another question, and that too very important, Megan. Most of our viewers ask, what if they fail? So, what are the
right.
implications for employers if they fail to comply with the H-2B program's recruitments, such as not adequately recruiting US workers or exploiting foreign workers?
Yes, this is something that employers should really be aware of to make sure they're following all the requisite compliance requirements, because there can be tangible consequences to not recruiting U.S. workers or exploiting foreign workers. There are civil monetary penalties that the Department of Labor can assess as punitive measure to deter future violations. The amount really just depends on the severity. They could be responsible for paying back wages to U.S. workers that were not paid the right wage. There's the corresponding worker requirement we talked about last time,
Mhm.
that U.S. workers cannot be treated in a way that's disadvantages them to the foreign workers. So, the foreign workers and the U.S. workers in the same type of job need to be paid the same H-2B prevailing wage, at least.
Mhm.
So back wages are something that's possible as well. That's something I've seen in the past. Debarment proceedings, you could be prevented from applying for H-2B in the future if you are found to have been in violation of the program. So, there's also, as part of the new H-2 requirements that the Biden administration slipped in effective January 17th, there's a question on the I-129 form that asks if they've had any labor violations, any immigration violations. There's a whole page of questions dedicated to what kind of wage and hour or any employment related violation that the employer may have been subject to that extends beyond immigration. That's a question on immigration form, but answering, it's too early to tell what the implications are going to be related to those questions that are on the form. But I personally haven't seen them come down, but I've seen a couple of colleagues in the field, other immigration attorneys, that have had requests for evidence or notices of intent to deny related to that question, asking for copies of those investigations. And we don't know whether that means they're not going to approve them or if they're just asking for more information as proof of those transgressions. We just don't know what that's going to mean at this point, but it is a burden on the employers, and it means that they really need to have their affairs in order and make sure they're following all the required government compliance for employees and immigration in order to continue participating in these programs.
That's right. I hope our viewers are getting to know a lot of things today, and also what are the implications and what rules you have to follow before hiring any US, any workers. So please go ahead and, check out our first episode also. There also we have covered a lot of information. And I can see a lot of viewers here. Surjit is here, Empire is here, Arpita is here. So thank you so much, friends, for participating in this webinar. We will surely take your questions up. But before that, I would like to go with a short break so that we can have more comments from your side. So don't go anywhere, friends. We'll be right back just after a break, and we'll uncover more important information in this topic. So thank you so much for being here, and keep watching Immigration Talk Show. Hello and welcome back, everyone, to Immigration Talk Show. Today, we are really having a great discussion with none other than attorney Meagan Kirchner. And the topic that we are exploring today is very important, especially for the H-2B visa applicants: how to legally sponsor workers in the US and work as a seasonal temporary worker, episode 2. So, till now, friends, we have covered one segment of this episode, and another segment is yet to begin. So, please, I can see a lot of comments here, and we'll surely take up a lot of comments after just 5 to 10 minutes. But before that, Megan, I have some more questions, and let me complete those, then we'll shed light on our viewers' comment.
Sure.
So here's another question that I would like to know: that how do industries like hospitality, tourism, landscaping, and seafood processing benefit from the H-2B program? And what specific challenges do these industries face in obtaining the necessary visas?
Sure. So most industries in this program really benefit by, being able to meet demands for their industry, whether that's staffing in a hotel, being able to fulfill contracts as a landscaper, being able to actually harvest and process seafood during key seasons when those, whether
Mhm.
the crabs or whatever it is that are in season. The program allows them to staff adequately, if not grow. Many of my landscaping businesses in particular, um, have worked with U.S. workers, have a sufficient U.S. staff, but have been unable to grow their staff, have been unable to add headcount, which doesn't allow them to expand their business, increase revenue, grow year after year. So this program really allows them to contribute to the economy, but make their businesses better and make them provide more services to, U.S. households. So there are benefits that are related to their community, to the economy overall, to their individual businesses. So, in some circumstances, without the program, years that they don't get workers for some reason due to limitations, you know, they're they struggle to stay afloat. They may lose contracts. It provides, reputational harm when they can't fulfill the
Mhm.
contracts that they need. They need staff to provide, and they cannot get U.S. workers during the high peak season that can meet demand or what they need to do as a business. So challenges that really cause those hardships are related to cap limitations. The cap hasn't changed for H-2B, since the 90s. So we have requests every April and October that far exceed the number of visas that are available. So many employers that file for the program you don't end up getting workers because the visas are gone by the time they get their application process through Department of Labor. They have the lottery every spring, and the visa numbers are no longer there by the time they get through the process. There's also, even if they're lucky enough to get through the process, consular delays and Department of Labor processing delays make it to where they miss part of their season, part of their busy season. So even if you get workers, by the time you get them through the consulate, it may be May or it may be June if you're working with
Mhm.
supplemental visas. So if your season starts April 1st, you've now missed 2 months, 1 or 2 months of your season where you needed workers and you got workers, but they didn't come in time. Um, so they're left trying to scramble and salvage their season, and seafood processing, things like that. That makes it to where, I mean, there's no one to process it. That's not where you can fulfill a contract later. That means that the product this just goes bad. That doesn't help. There's no way to the businesses have other options. Aside from that, from some industries, there's imperfect because of the cap. They may not have start dates that align perfectly with their season. They may be, for instance, lifeguards. In certain coastal areas. Maybe it's too cold to have seasonal workers in April. So your start date really is June 1st. Those people haven't been able to take advantage of the program for many years, except for the past couple of years, they've issued a separate small allotment for employers with a May 15th or later start date that have returning workers. So you're limited to workers that have had an H-2B in the past. But if you don't have workers or can't locate workers that have had an H-2B in the past and your start date of need doesn't align with an April 1st or an October 1st start date, then maybe you would otherwise qualify for the program, but you can't fit into the program as it currently stands because the cap limitations mean that you can't get workers on your start date.
Mhm.
Um, so the program has challenges, even for people that would otherwise meet all other program or eligibility requirements.
All right. All right, that's wonderfully explained. Also, Megan, I have another question that if we compare the H-2A and H-2B visa together, then
Mhm.
what's your recommendation? What immigrant should apply for, which visa, and why?
From an immigrant standpoint, the H-2B visa tends to be a longer season because H-2A is related to a particular growing season. But
Mm-hmm.
there are some benefits of H-2A to workers that you don't get with H-2B because for H-2A, the workers, the employers have to pay for their housing. and they're not subject to withholding like Social Security, Medicare, whereas H-2B workers are. So that can make a pay difference for many workers, because H-2B, you can, and some employers provide housing and some do not. Some offer housing, but then withhold for the cost of housing. So, there are pros and cons for that. For H-2B, um, sometimes the wages are a little higher, because depending on the industry.
Mhm.
So, because at H-2A, the wage is set from the AWR, so each state has a particular wage versus a particular wage for certain occupations. For H-2B, if you're working construction in the same city that you're a housekeeper, your wage for construction would be higher than your wage for housekeeping in most instances. So, you know, where you're working matters regardless. But
Mhm.
there are either for both of them, you would have the opportunity to, your employer pays for your inbound travel, outbound travel. So those are kind of the same across the board. But agriculture is obviously going to be outside. So if you're someone who doesn't want to work outside, H-2A is probably not the best fit for you. H-2B, there, you've got construction and landscaping, which may be inside or outside, but there are occupations, um, bartenders, restaurant jobs, hospitality jobs, that aren't necessarily outside, don't require heavy lifting or physical requirements. So depending on your skill set, H-2B may be a better fit. So it's really going to be a very personal decision on which is going to be more beneficial for each person.
Absolutely. I think that's pretty well that you have explained, Megan. And yeah, that's very well put up. It depends upon their situation, depends upon their skill, which visa will suit them. So
Mhm.
thank you so much, for putting up that. And I'm sure our viewers are really able to clarify, the difference between the two visa and which visa is going to be beneficial for them in the upcoming year or maybe upcoming time when they are applying for it.
Right.
So I think now we have asked a lot of questions from Megan from my end, and now let's. I don't want to delay our viewers, as they are eagerly waiting for these questions. So let's take up our first question from Surjit here, and he's asking, what are some key considerations for employers when hiring H-2 workers, especially regarding compliance with U.S. immigration and labor laws?
Okay, so for employers, there are many different compliance considerations that they need to take into account, and we covered a lot of those in the last episode, but really big ones are, making sure they're aware of, like I said, the recruitment requirements, making sure they're not disadvantaging any U.S. workers. The corresponding wage requirement is a tremendously important item. They need to make sure that U.S. workers are paid a similar wage to H-2B. They also need to make sure that they're prepared to offer the H-2B workers a full-time job. There's a 3/4 guarantee requirement. Um,
Mhm.
so whatever the contract hours are, they have to be at least 35 hours a week. But if you're offering, 40 hours, you need to have for every 12 weeks, 6 or 12 week period, depending on how long the contract is. You need to be prepared to offer the workers at least 3/4 of those hours for each 12-week period. So you have to have at least 32 hours for every 12-week period. If for some reason you're not busy or the weather's not good, you still are required to pay the workers that living wage, which is 3/4 of the contract hours. And so, it's the program is not forgiving in that, the employers still have to pay regardless of whether there's work. So you need to make sure you're ready to have a full season that keeps everybody busy. You also need to make sure that you're having the H-2B workers work only in the area that you've been approved. They can't work for another company. They need to be on your payroll, which needs to be offered, through, so you can get your own QuickBooks, Gusto, whatever payroll company you want to use, but they need to do withholding properly. They need to have a pay statement issued to them that has certain information on it, to be in compliance. The workers need to be able to see that pay stub. You can't just pay them in cash. So there's some procedural, administrative things that you need to be aware of. You need to be aware of costs. You're responsible for inbound and outbound travel costs, consular fees. The workers cannot pay for any part of this legal fees or visa fees. Um, those are tremendous red flags that will get employers into trouble. And those are just the highlights, but there's many issues that employers need to be aware of. If you're curious, you can look at the ETA 9142B Appendix B that outlines the entire all 26 paragraphs of employer attestations that they are saying that they will follow as part of the program. It's a fairly comprehensive list.
Yeah,
But record keeping is another part of that to make sure you're in compliance with all those things.
absolutely. All right. Thank you so much, Srujit, for putting up this question, and that too very important. Let's move ahead with the Yash question. How long can an H2 worker stay in the US, and what is the process for applying for an extension if more time is needed?
So the workers specifically can stay in the US for up to 3 years. That's different than the approval you're going to get from an employer side. So the employers will only be approved for 9 or 10 months for their season. But as a worker, if you complete 9 months with one employer and you don't want to go to your home country to get a new visa for another employer, you can the in-country transfer as an H-2B worker, you're cap exempt. So you can for up to the 3 year period. That's your max stay. You can transfer between employers through an I-129 name petition. So if the employer is willing to file a name petition and transfer in-country workers, you can transfer between employers with I-129 extensions and get an I-797 approval notice to extend your work authorization for up to 3 years, jumping back and forth as long as you've got no authorization gaps.
Mhm.
So, that's a paper process filing for extension. It's going to go between employers. You're not going to have a situation for H2 that you get an extension with the same employer, at least for H2B. For H2A, you may, there's extreme circumstances where H2A is more likely for an employer to be able to extend their petition. Individual employers on the H2B side can't extend their petitions or their season outside of really extreme circumstances, natural disaster, emergency, something like that, that is just extraordinary. So as a worker, you do have that flexibility to file extensions via USCIS, but your employer your new employer has to sponsor that. And to reset that, they just changed it from 3 months to 60 days. So in order to reset that 3 year clock, once you get close to it, you have to go to your home country or be outside the US for at least 60 days to
Mhm.
reset that clock. And then you get a fresh batch of 3 years.
All right. And is it possible, Megan, that after 3 years, they can also apply for the permanent residency?
Permanent residency is a very long process, and there is a category that in the kind of jobs that you would be able to find for H2B or
Mhm.
H2A, employers can sponsor permanently, but it doesn't give you work authorization while you're going through that process. So really you have to keep doing the H2 until you get to a certain process in the green card stage.
Mhm.
Um, at which point you'd be eligible for work authorization. That category is backlogged right now at the Department of State. There's not enough permanent visas available every year. So there are paths to a green card via employer sponsorship if you're on an H-2 visa, but it's a long process and it's not as predictable as it used to be a few years ago before the category was backlogged. It used to be that you could reliably expect a 3 to 5 year process and then you could probably get a green card, but now you make it through the 4 or 5 years, and by the time you get approved, you have this piece of paper that says you're approved for an I-140, which is the immigrant petition, but you can't get that green card from the consulate or via adjustment of status because there's no
Mhm.
immigrant numbers available to you to complete that last step. So short answer is yes, but it's a little nuanced and it's quite long at this point.
All right. Okay. And let's take Empire's question. So, Empire is here asking the regulations states that returning worker allocations are for workers who were issued H-2B visas or held H-2B status in
Mhm.
fiscal year 2022, 2023, or 2024. So,
Mhm.
if you had H-2B status in 2024 from extension of stay, but your last visa was issued in 2021. So, are you eligible for returning visa given that you held H-2B status from 2022 to 2024 from extension of stay? Yeah.
They wouldn't have had a visa issued and been counted against the cap in one of those years, so they wouldn't be a returning worker because their last visa that was issued wasn't issued under the cap. Um,
Mhm.
it's possible that they would process you, but the consulate wouldn't have records. So technically speaking, you wouldn't be falling in that category. If your visa was issued in 2021, you just did extensions of stay to get 797s in that process. Um, so those workers, probably won't be able to get it through the consulate, but it's,
Mhm.
there is a lot of subjectivity, at the consulate where they may accept it. It's not exactly clear cut. So I wouldn't expect to, but it is possible that an officer would let them through.
All right. Okay, and thank you so much, Megan, for putting that up, and Empire also. In case if you have any follow-up question or would like to know more about this topic, then please go ahead and put up in the comment section. We will definitely take them up. Let's take Arpita's question. Arpita is asking, how does the H-2 visa program help address labor shortages in certain industries in the US? And what impact does it have on the economy? We already have this discussion, but still, if you would like to add on to it.
Um, I don't really have a lot to add. The typically from employers I've worked with and from a lot of industry data, it does provide substantial influx of capital in the economy because there's more services available. There's more contracts that can be made. So industries, people in these industries are able to grow their businesses and contribute it to the economy, and people are able to engage with these companies, from the consumer side because they've got capacity to do your projects, or their hotel is staffed so that they're able to provide more service, or their restaurant can keep up with demand. There's many ways that this program can help stimulate the economy.
Absolutely, that's right. And with that, I have another question from Rekha. Thank you so much, Rekha, for being here. Rekha is asking, can H-2 visa holders apply for a change of status to another visa category while in the US? Yeah.
Sure. As long as they meet the eligibility requirements for the other visa category, whatever status they're trying to change to, they can certainly file a change of status while they're in the US, while they're on their H-2 visa. The only difference there, that comes up sometimes, or a question that comes up often, is whether an H-2A worker can switch to an H-2B visa in the US, because employers are like, oh, this guy's H-2A, can we just switch him to H-2B?
Mhm.
The only way they're going to be able to do that is if the employer has cap subject visas. That doesn't H-2A to H-2B status. You can't do it if you haven't been subject to the cap, if the employer hasn't been subjected to the cap, because then there's no cap exemption for H-2A to H-2B. But generally speaking, as long as you meet the other category change, that you're trying to apply in, then yes, you can change just like any other visa.
All right. And here's a follow-up question, I guess, from Rekha, that are there specific visa categories that an H-2 visa holder can transition to while staying in the US?
Some H-2 visa holders can have transitioned to a visitor. Maybe they're doing medical treatment from a workplace injury, or maybe they have something to take care of. You could transfer to a student visa. Um,
Mhm.
Based on generally the skill set of many of the workers that are in H-2 positions. Some of the other non-immigrant work categories probably aren't going to transfer well because there's a degree required for many other programs. You can adjust status. If you did successfully make it through the green card process, you can adjust status from H-2 um, to the green card pending status, assuming that you don't
Mhm.
have you've gone beyond the time period in the U.S. to not trigger immigrant intent. So that's a possibility as well.
All right. Okay. And we have RK here. RK is asking, what is the government doing wrong with the H-2A program? Because it uncapped, but there are so many undocumented agricultural workers in the US. What is causing the discrepant? I think, yeah, we already talked about it, but still, I think you should let RK also talk about it.
There's a lot of red tape that's intended to protect workers in the H-2A program. So it's a tremendous burden for for employers to employ H-2A workers. There's legal fees, there's government filing fees, there's all the travel fees, there's wage requirements, there's housing requirements, meal requirements. There's insurance requirements. So many of these things employers should probably have anyway, but those are things that if a farm is employing undocumented agricultural workers, they may not be having to do some of these administrative tasks or have some of these costs that would be associated with participating in the H-2A program. So those are reasons why some companies or farms, employers may not participate in H-2A because it's just easier to not.
Mm, absolutely, that's right. I hope, RK, you got your answer. And this is a very interesting question, but everyone is trying to find out the answer. And hopefully, after few months or maybe just after a few days, we got to know some different, better information or better executive order that may come up. So we'll definitely let you know about it. But don't forget to like, share, and subscribe to Immigration Talk Show because we come up with so many information and obviously just to let you guys know about it and let you guys make you update about all the information that's happening in the world of immigration. So Megan, we have covered viewers questions and my questions too, but I would just like to take your permission regarding shedding light on Facebook questions as well if you have some time. So could
I
we
do.
go ahead? All right, that's great. So, Control, if you could have these questions. Okay. So, here's a question that, hi guys, I have a question. Someone hired me as a dishwasher for H2B out of country, but my experience is bartender. So, do you think this is fine in the embassy interview? Thanks in advance.
Sure. Most H-2B positions don't have an experience requirement on their job order. So if the job doesn't have an experience requirement on the work contract that you've been given from the employer, they're not going to look at whether your experience aligns with the position. This is most of these jobs,
Mhm.
are no experience required positions. So it shouldn't matter whether you've ever had a job before or whether it's relevant if you have.
All right. Let's take up the next question. Hello, everyone. How do you think the labor situation will turn out with mass deportations? Do you think that perhaps more H2B work labor would be needed? Yeah.
Yeah, we've touched on this kind of in some other questions, but yes, if for some reason, the mass deportations actually happen and the undocumented labor force becomes scarce, the expectation would be that more employers would be forced to turn to H-2B labor if they're able to. As it stands, there's already far more demand than there is supply of H-2B visas. So how they would, fall into that, it would require, I don't know the answer to that. It would require some sort of change or expansion of the program for that to be a viable option for them.
Absolutely. All right. Let's move ahead with our next question. This we got from anonymous participant who was asking new H2B worker aspirant here. Now I'm trying to navigate how this H2B things work. So I'm out of country, then I have employer already done with the interview and employer asked me to submit the copy of my passport and recommendation letter from my current employer here in my country as a supporting documents. So the question is this is already an assurance that they can hire someone outside of the country. Well, they get category A, and now when I check the case status in the website, it says approved pending recruitment. In this case, what do you think is the chance to get full certification? And after full certification, what's the next step? Yeah.
So if they're in group A from the lottery assignments and they're already in recruitment, meaning they've gotten their notice of acceptance, there's a better than not chance that they're going to get their full certification. It's going to just depend on whether or not they have to hire, how many workers they're asking for, and whether or not they have to hire U.S. workers as part of the recruitment process. But that's the best possible scenario for most employers, to be in group A and to have made it through recruitment already. And at this point, they're just waiting to complete recruitment and get their certification. And once they get to full certification, they will take that certification to file for the non-immigrant visas with USCIS. So once they get certification, that process with USCIS, most employers will file with premium processing. So within 15 business days, you'll know whether or not they get approved for visas from immigration services. And once you have a case number for that, they'll be able to schedule you at the consulate. So this is a good situation to be in.
All right. Let's move ahead with another question. This we got from Natali, I guess. Hi, I'm a first timer. How can I get a job as a housekeeper with the H-2B program? Can someone help me, please? Yeah.
This is a difficult position to be in, to be a new H-2B worker trying to break into the program, because there's just so many looking for jobs all around the world. There are various Facebook groups you can join. There are, depending on what country you're in, there are recruitment agencies that recruit qualified H-2B workers that will help pair you with an employer. A lot of U.S. employers don't have workers already, so they will engage an agent to perform recruitment services. One important thing to note as a prospective H-2B worker is you should not be paying any fee for any part of this process. So if an agent or a recruiter tries to charge you a fee, that's unlawful. The employer is going to get in trouble for it. The employer may not even know about it, but you don't want to put a prospective employer in that situation. So don't pay, regardless of how much you want to come, don't pay a fee to that recruiter, because it's not a reputable recruiter. So really that's the only way to do it. Some workers will go to seasonaljobs.gov and try to apply for jobs there. A lot of U.S. employers, they, as part of the recruitment process, need to screen U.S. applicants. It can be overwhelming for them to get applications from hundreds of foreign applicants. So that may not be the most effective way to do it. It's just cold emailing employers that are filing with DOL. Those may not get a response. Working with a recruiter and agent is probably your best bet. Or word of mouth, if you know someone else who participates. Referrals from existing U.S. worker H-2B workers for new U.S. H-2B workers is the best way to do it. Aside from if you know people that work in H-2B.
Absolutely. All right. So these were some of the Facebook questions that we wanted to ask questions from you, Meagan. But with that, we already crossed 1 hour, and I still would like to end up this session with my very first last question, because this is really important. So, is there any final strategy H-1B applicants should consider after receiving an RFE to strengthen their case?
For H-1B, it's once you get the RFE, more than likely in this day and age, you're probably getting what we call a kitchen sink RFE, meaning USCIS is asking you for everything under the sun. Most of this is really going to be for employer focus. So it's going to be a burden on the employer to prove that this position, is specialized. So they're going to be working with their attorney to strengthen their response and pull job postings that are similar. As an employee, as an prospective H-1B applicant, there's really nothing that you probably would have had to do to strengthen the application. They just need your registration and your passport and your education documents. It's going to be incumbent on the employer to prove that position qualifies for H-1B. Short of there being some issue with your education evaluation or something like that, that would require some explanation of your coursework or something. Be responsive to your employer requests. and their attorney's request if they have one. If they don't have an attorney and they're trying to respond to an H-1B RFE, that I would recommend that they try and put at least the RFE through an attorney if they didn't file initially through an attorney, because the RFEs can be challenging even with an attorney these days.
All right. Actually, Megan, this question was asked from a viewer, and he is watching our session, but he just put up in my WhatsApp, so that's why I just took up it. I know it's about H-1B, but I think I should definitely know it from you because you are an expert, and he was really looking towards your information. So thank you so much, Megan, for taking this question as well, and all the questions, all the Facebook questions, viewers' question, so patiently and. That too in a very detailed form. So thank you so much for being here.
Sure.
We are really happy to have a show with you. This is the second time, and still it doesn't feel like we are connecting for the second time. So and that's lovely, and I really enjoyed, and that too I'm so happy. We got such a lot of engagement.
Mhm.
So we are really honored. Thank you so much for being here.
Thank you so much for having me. Hopefully everybody got their questions answered. If they didn't, feel free to reach out. I'm happy to help.
Absolutely. I'm sure our audience will, and friends, even, you can look up the contact details of attorney Meagan Kirchner. Here's the phone number, that is 434 with the email ID is megan at kirknerimmigration.com, and the
Great.
website is www.kirknerimmigration.com. So
That's
please
great.
go ahead, reach out to her, and let her know about how's your immigration journey and any problem or any expert advice if you would like to know from her. So thank you so much, Megan, for being here, and we are looking forward to more shows with you.
Thank you. Have a good rest of your day. Appreciate it.
Same here. All
Thanks.
right, friends, thank you so much for being here. And, it was really a wonderful show. It was very informative and lots of different perspective also we got to know in today's episode. So thank you so much for being here and participating too. Don't forget to like, share, and subscribe to Immigration Talk Show. We are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. So check out us there and do let us know what your questions are, or if you're looking towards to have more different topics, we will definitely love to cover those topics in our upcoming webinar. With that, friends, thank you so much everyone for being here. I'm Sam signing off for now. Goodbye everyone and take care.